The phone call. My mother died last night. Dominique's voice was a paper-thin thing, caught somewhere between practiced sorrow and a performance. It came through my phone like a radio signal crossed with a sob. I stayed where I was in the kitchen, hands hovering over a mug of tea, and turned. Mama Estelle was in the living room, in the square of sunlight, where the curtains met, moving slowly, hands circling her bread, tipped like someone listening to him. She was doing Tai Chi the way she had done it for 20 years. Slow, exact, and entirely alive. There are moments when your mind refuses the easy conclusions. Only later would I realize how perfectly that lie had been timed. The sobbing call, the assertion of death, the theatrical plate of grief Dominique was selling to neighbors and strangers. At that instant, all I felt was a hollowed-out disbelief. I pressed the phone to my ear and watched Mama's shoulders roll. I heard the script rattle in Dominique's voice. We had to cremate her. I'm so sorry. I heard the understatement and the promise of finality in one breath. This is the image the title promises. My sister called in tears to tell me our mother had died. I stood up from the table and walked into the room. Mama, Estelle smiled at me over her cup of tea. That small, everyday gesture made the call into a provocation. It made the promise of this story. Someone had staged a death to steal a life's work. If this story pulls at something in you, if you follow investigative threads the way I read bank statements, then stay. If you've ever been the family problem who tells truth that others prefer buried, hit like and subscribe, and tell me in the comments if you've been the one to ask the awkward questions. Te hagai brownstone. Our family home was the kind the city lights used for postcards. A narrow brownstone with a stoop that creaked in winter. A small garden that smelled of rosemary and tomato in July. And windows that caught the late light in a way that always made the living room look like a painting. Mama, Estelle, choir leader, seamstress for neighborhood brides, the woman who gave away soups and scarves, kept the house. She kept everything in the old way, with lists, with envelopes. With a tidy ledger, she called Estelle's register. The ledger sat in a drawer beside her prayer book. It was a registry of birthdays and favors, a catalogue of the people who lent her sugar and the ones she lent trust. Dominique had not shown up at the house in years. She'd moved to boroughs over, changed her haircuts, and built a social life that operated on a different set of currencies. There had been fights, money, an old unpaid loan. Who took which china plate at the funeral of Papa? Whatever the smaller grievances were, they hardened into estrangement after a decade of silence. Sheik's Munswine wants to demand. I was the steady one, the one who came over with groceries, the one who handled the bills when Mama could not. I am a forensic accountant by trade. I build narratives out of ledgers and timestamps. That profession gave me a certain arrogance. Numbers do not lie, and a certain humility. People do. The morning of the call Dominique made, I had been reconciling a corporate tax return, but my careful margin notes were replaced, in the next hour, by a checklist that had nothing to do with revenue recognition, who had the key, where the original deed was, and whether Mama's health proxies were current. I moved into inventory, mowed the way a surgeon moves toward a wound. The first clues. The first hour, after Dominique's call, felt like being inside a locked room with a television playing only. Commercials for grief. Neighbors texted condolences, friends sent prayer emojis. And an Instagram pull for celebration of Mama. Estelle started to thrum in my notifications. Dominique had already posted photos. Mama in a Sunday hat, Mama with a church choir, Mama smiling next to a cake. The captions were immaculate. Our beloved passed peacefully. Funeral tomorrow. Donations to help cover her services appreciated. A fundraiser link glowed at the top GoFund titled, "Honoring Estelle Williams." I do not say this to editorialize. I say it because the mechanics of modern theft are often social as much as they are technical. A grieving post mobilizes community. A verified-looking fundraiser invites trust. When a family member with a story of finality accompanies that post, people give. And they give fast. The GoFundMe had raised money within an hour, small amounts, generous for a neighborhood. Then the withdrawals followed. The payout route on a platform like that is not invisible. There are merchant accounts, intermediate processes, and the last mile account that receives funds. I trace the latest deposit and found, according to a screenshot the fundraiser later release, and bank records I would obtain, that the payout was directed to a card that carried a Neiman Marcus line and a name I'd never expect to see on a primary account for my mother, Dominique, Sterling. Exhibit A GoFundMe payout. Screenshot alleged. Timestamp donation list. Payout destination showing last, for digits of card tied to Dominique's merchant account. Total raised $3,420 in the first 12 hours. That was the first small, telltale mismatch. Moving from social evidence to financial evidence was the same movement I made in my professional life, from claims to ledgers. I pulled up digital trails. And where I could not pull them immediately, I called people who could. A private investigator I'd worked with on a creditor dispute. A family lawyer friend named David who owed me a favor. And, later, a neurologist I trusted in Boston who would rent me the vocabulary to challenge certain signatures. The moving truck. At noon the same day, I drove by the brownstone and found a moving truck at the curb. It wasn't anonymous. The company's logo was visible. The truck's plate estate number 1 photographed. The movers wore uniforms. They were careful, efficient. They crated framed photos, boxed up linens, and politely loaded 3 heavy trunks of something that had the smell of cedar. A sale pending sign had been placed on the lawn in the small, precise handwriting of a real estate agent. I parked down the block, hands steady in the wheel, and watched. That truck and that sale sign were not the only logistical mechanisms of what had been set in motion. There had been a legal paper chain. The nursing home Oak Haven had a folder with a guardianship petition dated 3 months earlier. Someone had produced a durable power of attorney, ADNR, and a medical guardianship assignment. The forms had looked plausible at first glance. The signature did not look like Mama's. The ink pattern was off. But signatures are notoriously tricky to challenge without professional support. That is what I had, the skill set to know where to look and whom to bring in. I called Reynolds, the PI, and asked him to photograph the truck, the license plate, and the real estate agent's business card. I told him to ask neighbors to save any texts, emails, and mail that came through. I asked David to begin the process of filing for an emergency injunction to stop the sale. I told them all the same line: don't touch anything and preserve custody of the evidence. Chain of custody would matter later. Exhibit B, moving truck documentation, photograph, series 1 to 7. Time-stamped license plate. Moving company receipt alleged, showing 3 crates moved on date X. A private investigator's first calls are always to human beings' neighbors. Doorman, the guy at the bodega, who notices everything because people are both witnesses and carriers of small truths. Reynolds sent me camera shots of a man in the moving truck who carried a gym bag with a logo I recognized, an old collegiate crest tied to Hunter Sterling, Dominique's son-in-law. That gym bag, in the world of evidence collection, was like a fingerprint. The DNR do not Resuscitate was the most malignant of the documents. In the records Oak Haven produced, there was an advance directive apparently signed by Mama, Estelle, for months prior. The directive listed Dominique as power of attorney and declared that in the event of severe cognitive decline, resuscitation is to be withheld. It was precise, clinical, and devastating. Oak Haven relied on it. The nursing staff had circled back to that directive when someone asserted a sudden terminal decline. I knew enough to be cautious. Signatures can be forged, papers can be misrepresented, and pressured consent is a legal category in its own right. I asked for a copy. Oak Haven provided a redacted scan. At first blush it looked like a clean document. But then Reynolds sent a close-up. The ink stroke of a line did not match the pressure patterns in other documents Mama had signed. The notarization seal was a smudge. The notary listed had no record of attesting to that form on the date listed, according to a municipal registry query Reynolds conducted. Exhibit C DNR alleged, redacted scan claimed by Oak Haven. High contrast close-up, showing ink pressure inconsistencies. Notarization discrepancy, flagged. I will not pretend here that this is a textbook forgery lesson. I will say this. The DNR looked like a legal instrument, but carried anomalies and inconsistent notary record. An ink pattern that did not match verified signatures, and a date of notarization that coincided with a series of withdrawals on a credit card tied to Hunter. The set of coincidences was enough to warrant a criminal look. Social media, the Instagram fundraiser, and a small lie. Money moves like gossip. It jumps platforms. The GoFundMe had been linked in an Instagram story. That story was shared by a handful of accounts whose handles looked curated. Church members, neighbors, a small influencer who had once sung in Mama's choir. The post had the kind of authenticity that tamped down suspicion. It had heart, and it had the correct names. But in the metadata of the post, the JSON record I later obtained through a preservation order, the IP address trace showed the post was uploaded from an IP block that geolocated to a commercial office park in Queens. The registered address of a shell company I later would map to Hunter's set of businesses. This is where the technical met the personal. I could say I charted IP addresses, but what mattered to people was this. The story, selling Mama's death, was published from the same place that had registered a recently formed LLC that Hunter used to receive wires. That public evidentiary link is the sort of thing that silences the "this was just a mistake" narrative. Reynolds' note paraphrase. Reynolds sent a simple message at 6:12 p.m. to receipts for Neiman Marcus on May 3. Moving crew left at 11:02 a.m., same day as withdrawal. DNR notarized on May 2nd. Notary office denies attesting. Peaks of Crate 3 show family silver. Suspicious. I printed those messages and taped them to a whiteboard in my kitchen. The board read like a dossier. Timelines, receipts, phone numbers, and a small Polaroid of Mama at church in a blue dress. The human picture reminds you why you do this work. Establishing the forensic facts is not an exercise in winning. It is an exercise in restoring dignity. The church and the congregation. Mama's church, St. Matthew's, was both sanctuary and market. She had led the choir for decades. She knew everyone's children. When Dominique announced the funeral, churchgoers responded with a flood of messages. Flowers began arriving at the church steps. Old friends posted condolences. Dominique showed up in a fitted dress. Fussy composed people embraced her. She hugged hard and spoke of Mama's humble passing, The congregation's trust was evidence in itself. But trust can also be weaponized. Someone with public presence can alter public perception quickly. My job in that moment was to match the social narrative with documents. It was to make the story of the theft visible to people who had no taste for ledgers. I reached out to Pastor Lewis. He was a kindly man who said church matters first and court matters second. He promised to keep a place for me at the service. I asked him not to proceed with cremation until there was an opportunity to verify medical records. He agreed to pause forms of final disposition pending confirmation. He could not stop people from giving to a fundraiser, and he could not stop a family member from speaking. The pastor's moral restraint bought me 48 hours. Te haga audit. When you conduct an audit of a household, you read the obvious pages and the pages nobody wants to touch. I took the ledger Mama kept and compared it to the bank statements I could access. Some entries were small payments for a TV repair, a series of checks for groceries at a market in the same block. Those added texture. What I looked for, clinically, were anomalies, withdrawals that did not match the ledger, new credit lines, and property records. There was a reverse mortgage on the brownstone. It was an instrument that, in theory, allows a homeowner to draw against equity while occupying the property. The occupancy clause in that mortgage routine in most agreements required that the homeowner live in the dwelling for a specified continuous period, usually 6 months. If the house is vacant, servicers may call the loan due. That clause, and its practical implications, would later become a critical lever in the financial battle that unfolded. For now, it loomed quietly on the margin of the ledger. Exhibit D. Reverse mortgage note public, record recorded date original lender. Occupancy clause excerpt alleged. Notation requires continuous occupancy. Breach may trigger acceleration. I pulled bank statements checking, credit cards, and an old savings account Mama kept with a modest amount. There were withdrawals I could not explain. A payment to a Sterling Holdings popped up an essay, transfer to an LLC with the same name as Hunter's business. A set of payments to a cardiology practice in the city ones stamped. Consult, another labeled home visit, coincided suspiciously with the date on the DNR. Those payments could have legitimate explanations. Doctors do charge. Families do take extraordinary steps. But in the aggregate, patterns tell stories. The Presca Manila envelope. Reynolds left the envelope with my building manager. It was a small thing photocopies, a milk bottle of receipts, and one crisp print I would later use in court. Inside was a copy of a handwritten note that had been left in the mailbox of a neighbor. We're sorry for your loss. Services tomorrow. Inquiries to D. Sterling. The neighbor had circled the envelope number with a blue pen. There was also a security camera grab of Dominique, hurriedly placing a box in the trunk of her car at 9:38 a.m. On the day of the alleged death. The PI had done what PIs do best, make visible what the conspirators wanted to hide. The envelope had small, human things photographs, receipts, and a photograph of Mama's sewing box, open on the kitchen table, its contents half removed. Whoever took that photograph had been careful enough to include a runner's receipt around the box, as if to ensure there was a record the box had left the home. That runner's receipt matched a delivery service that listed a business name tied to Hunter. What made my stomach turn was not the money alone. It was the pattern of carelessness and calculation, a DNR to control consent, a fundraiser to monetize community grief, moving crews to extract tangible assets, and a web of small transfers that moved belongings into hands that had a motive and a method. Te aga ilegautim. David, the lawyer, arrived with legalese and warmth. He is the sort of lawyer who may irritate judges because he is always precise, but he is gentle with people. He told me 3 things. Do not circulate allegations publicly, preserve evidence, and prepare to file emergency litigation to halt the sale. He asked for an itemized list of missing items and for copies of the ledger and bank statements I had flagged. An injunction is a blunt instrument, he said. We can ask the court to freeze the sale and require an accounting. But the DNR and guardianship claim complicate things if Oak Haven attests the medical record is legitimate and the court recognizes a guardian. That will change the posture. We need to be surgical. That sentence, we need to be surgical, felt like a counterweight to the performative grief on social media. It reminded me that the law is a muscle you must train, and that muscle responds to evidence. Exhibit E, Initial Injunction Draft Paraphrase, Emergency Petition to the Court, seeking a temporary restraining order to prevent sale, conveyance of property pending forensic review, request for preservation of records from Oak Haven. The funeral announcement. Dominique set a funeral for 4 days out. The date arrived on an email chain that included the pastor, a funeral home, and the names of neighbors. The congregation began to arrange a wake. Flowers multiplied. The GoFundMe continued to take small donations. In private messages, people offered condolences. In public, Dominique thanked them and promised an eulogy that would honor Mama's legacy. At this point, the simplest move seemed obvious. Call the funeral home and ask them to hold the body. But there was no body. Oak Haven claimed to have performed an orderly transfer. The funeral home claimed to have received the body and prepared it for cremation. For each claim there were documents. Each document needed to be examined. I asked Reynolds to get me a receipt for the cremation. He returned with a photocopy of a cremation authorization form, more precisely, a document with a signature block listing Dominique as authorized to consent. The authorization bore the same pattern of ink pressure anomalies as the DNR. It also included a line where a licensing official had signed off. That licensing official's name rang a faint bell, and a call to the Municipal Licensing Bureau revealed that the official's signature on their internal roster did not match the one on the cremation authorization form, detail that would later become important when establishing irregularity in the chain of custody for the supposed remains. But all these discrepancies, as David warned, did not automatically translate into immediate relief. Courts are conservative when it comes to family decisions. You must prove, not just assert. You must show a pattern. You must be ready to demonstrate that documents are not only inconsistent, but likely falsified. Te agai plan. I do not enjoy public spectacle for its own sake. I also understand that sometimes public spectacle is the only thing that breaks through a fog of plausible deniability. If Dominique had planned the stage, if she had engineered a performance of grief to extract assets, then the counter-performance had to be carefully considered. We needed a thing that would utterly undermine the story she wanted to sell, that Mama had died, that Dominique had acted in good faith, and that the sale was just part of necessary estate management. The idea that coalesced in my head in that week was both tactical and theatrical. It leaned on the community's own assumptions. Funerals bring people together. A funeral offers a public theater in which claims are confirmed or contested. If we could create a controlled moment, something incontrovertible, that would reveal contradiction in Dominique's Narrative then we could shift public sympathy and provide police and the courts with the breathing room to investigate without the smoke of an engineered outcry. This is a dangerous thing to say aloud. Sometimes you must risk being accused of theater to reveal truth. I would rather have truth than reputation. Exhibit F timeline working. Day 0, call an Instagram fundraiser. Day 1, moving truck and DNR. Day 2, pie photos and cremation authorization. Day 3, emergency petition filed. Day 4, funeral scheduled. Te hagai risks. A plan like the one I sketched had geopolitical risks. It would place Mama in public view. It would risk a confrontation. It could invite police intervention. It could provide Dominique the openings she needed to manufacture a new legal narrative claims of coercion, contested guardianship, and alleged mental instability of the so-called victim. I was aware of these risks because I had seen similar plays used by bad actors in elder conservatorship disputes. The difference here was that I knew numbers. I knew how to follow paper flows. And I had a network of allies who could translate paper anomalies into legal pressure. But that advantage comes with cost. You step into the public square, you make accusations, and you open yourself to attack. I slept poorly that night. I dreamed of Mama's ledger pages fluttering like leaves and of a pair of hands folding each page into a little coffin. I woke and kissed her forehead and promised I would keep records. We moved quickly. David filed a preliminary motion to preserve evidence and to compel Oak Haven to produce original documents. Reynolds continued surveillance. I prepared the narrative that would be presented at the church, a simple set of facts, laid out calmly and without melodrama. We would present the anomalies. We would ask the congregation to refrain from disposition until the court had a chance to review the documents. We would not shout. We would not accuse without cause. We would show. There is a small ritual about entering a church. When you are about to contest grief, you want to be respectful. You do not want to appear opportunistic. Yet you also know that timing matters. The window between announcement and funeral is a fragile, narrowing corridor. At the rehearsal of our plan, I asked Reynolds to bring one more thing, a pen. Not a dramatic prop, not a gimmick, but a pen whose ink chemistry I knew would react with certain solvent ink that would visibly fade after 60 minutes. There are ways, when you are forced into a performance, to control a moment without resorting to falsity. The pen's purpose was to create a time-stamped micro-event. An admission recorded in ink that would be visible at a set, later moment. I told no one the technicalities, no one needed the chemistry, but I told David and Reynolds that at the pulpit, a signature would be solicited and time-stamped. We met at St. Matthew's 2 hours before the wake. The pastor had reserved the side room. Dominique arrived early, as if to plant herself like a flag. People began to assemble, neighbors I knew since childhood, older women with hats, church members who had sung under Mama's direction for decades. The organist tuned the strings. I felt the weight of the crowd, the way you feel a pressure at your temples before a storm. I have found, in my work, that moments of public truth are best served by plainness. So I prepared a plain page with a simple statement. I, Dominique Sterling, affirm I am acting as the lawful decision-maker of Estelle Williams. I placed the page on a clipboard. I set the pen beside it and told no one noise of the mechanism I planned. At 10:55, I walked into the sanctuary with David and Reynolds at my side. There was a softness in Mama's corner where the sunlight pooled. People talked in hushed tones. We took our seats near the front, in the pew that held a perfect view of the pulpit. Dominique was already in her place, poised for eulogy. I folded my hands in my lap and felt the pen under my palm like a small, cold promise. 7 hours to the funeral. Te hagai ahorhichis. At 10:55 the organ stopped tuning, and the church exhaled. The light through the stained glass turned the aisle into a river of muted color. I felt the pen under my palm like a small, private talisman. Dominique rose to deliver a eulogy composed over a week of rehearsals, each line polished to soothe and to steer. She spoke of Mama's faith, her thrift, her love for the choir. People wept. Someone handed out him sheets. The rhythm of grief began to act like a cannonade, messy, communal, immediate. When Dominique finished, she lowered her face as if in prayer. I stood up. The room registered the movement like a change in weather. I walked to the pulpit, and I spoke in a voice that was steady because there was a dossier in my pocket, and because, for the first time in days, I felt permission to use it in public. St. Matthew's has been my family's home, I said. This congregation has buried and baptized and fed us. Before we proceed with final disposition, there are questions about documents that placed Mama at Oak Haven and authorized cremation. I did not shout. I did not perform. I read 3 sentences facts connected to dates and receipts, and then I asked the pastor, bluntly but gently, to allow a brief verification before the service continued. It was what I had promised David and Reynolds, plainness. It was also what the congregation owed Mama. I asked for Dominique to confirm, in front of everyone, that she was acting as lawful decision-maker and that she had authority to proceed. She glanced at me, a look I would try to name later anger-laced, with something like calculation, and then she signed. The pen left a neat looped signature at the end. Hands in the pews leaned in. The signature was the exact public moment I had prepared for. It was a public act that created witnesses, and it was carried out on a paper I placed on a clipboard so the crowd could see. At that exact second, the heavy side doors at the back of the church eased open. A ripple of curiosity moved through the crowd. The funeral director approached the casket stand and set down a small, golden urn on the altar platform as part of the ceremony. The urn caught the light like an accusation. Then Mama walked in. She did not stumble or appear dazed. She trod the nave with deliberate steps, holding a small thermos. She wore a worn coat and the same blue dress from the photograph on my board. People gasped. The organ's last chord fell into silence. Dominique's face did something then that I will not try to make theatrical now. There was a fracture between what she expected and what she had staged. Mama came forward unhurried. She looked, for a moment, like any woman who had been called somewhere and discovered that her life had been placed on a stage without her permission. She walked to the altar, reached out with one hand, and knocked the urn gently. Sand spilled across the purple cloth, a quiet, granular deflation of the story Dominique tried to sell. The sound of sand spreading was low but absolute. It was as if the entire house had been cleared by a broom. People stood up. A chorus of voices rose, surprised, relieved, angry. The lady to pews behind me started crying audible, blessed, relieved tears. Dominique shied like a creature surprised mid-hunt. Exhibit G, urn reveal photograph alleged, time-stamped image showing urn tipped, sand spread on altar cloth. Crowd, reaction captured at 11:03 a.m. For a moment, the church dissolved into a confusion of questions and shouts. The funeral director insisted he had received remains. Dominique protested that this was a mistake. Somebody reached for Mama's arm. She drew back and said, in a voice that still had the cadence of prayer, "I am right here." It was a theatrical apex, in the exact way I had hoped. The community had simultaneously witnessed the performance, and its collapse. The public evidence was visceral, an urn that held sand, but spectacle cannot replace process. Within 10 minutes we were no longer a congregation, we were a crime scene. The police arrive. They came not as a chorus, but as metal and protocol. 2 patrol cars pulled up at the church stoop. I had told the pastor earlier to expect law enforcement if Dominique, or her confederates, tried to escalate. We now found ourselves in the middle of what the police call a domestic dispute, with potential criminal elements. Detective Miller, a steady presence from the precinct, took the usher's statement while officers moved through the pews taking names. At first, the officers were sympathetic. They photographed the urn, took statements, and began inventorying the spilled sand as if it were the most damning piece of evidence. Someone from Oak Haven arrived by taxi, breathless. She carried a photocopy of a death certificate and a file labeled transfer paperwork. She insisted, in front of the officers, that the nursing home had completed the transfer properly and that the funeral director had processed a cremation authorization. The tone shifted. Hunter appeared at the back of the church, not in the tailored local business attire. He wore 2 fundraisers, but in a casual windbreaker. He stood behind Dominique, with the look of a man eyeing outcomes and opportunity. He approached the officers with a single sheet of paper what he presented as an emergency guardianship order granted by a municipal probate clerk and a police officer in Minnesota. I had not seen that document before. An officer I trusted read the sheet, and I watched his face change the way someone watching an algorithm run into an unexpected variable watches the screen. He asked for identification for the person he claimed had granted the order. 2 things happened fast. The funeral director insisted the church was a private property where no seizure could occur without legal process. And Hunter, leaning harder into the frame of urgency, began to claim that Mama was a danger to herself and must be taken to a facility immediately. I will be blunt. The power of a piece of paper in that moment was enormous. The officers are trained to rely on documents. It is how they separate figments from facts. Hunter's sheet looked, at first read, plausible. It bore what appeared to be municipal letterhead and a stamped signature block. The officer called his supervisor. The phone calls took the tempo out of the room and replaced it with regulation. Within 40 minutes, the tenor of the response shifted. Officers, worried about the potential of an unauthorized medical care interference claim, informed us that they were going to take Mama to a hospital for evaluation under a psychiatric emergency hold, pending verification of guardianship claims. I watched the priest argue innocence and duty, heard the pastor plead for more time, and then saw Mama escorted out in a way that looked more like containment than compassion. The officers did not handcuff her. They did not need to. They held papers and procedure like a shield. I was stunned and furious. A public reveal had instead created an opening for the antagonists to retaliate with institutional power and old playbook. Manufacture an emergency to regain control of the narrative. Exhibit H. Police officer notes alleged paraphrase. Timestamps of calls to precinct supervisor. Notation of presented order probate stamp. Proceeding to hospital for evaluation. List of witnesses. My arrest. It happened in the lobby of St. Matthew's while I was negotiating with a funeral director and the pastor. Hunter's friend, a man I later learned was an attorney for one of his shell entities, produced a photocopy of an alleged court order claiming I had issued threats to Dominique and that I had interfered with the disposition of remains. The officer read it aloud, looked at me, and asked if I had anything to say. I had many things to say, But an officer's right to effect an arrest rests not on my oratory, but on probable cause as it appears on paper. The cop placed me in handcuffs with a mechanical calm that felt rehearsed. The congregation murmured. Mama, who had been waiting in an adjacent room for transport, reached for me and told me, almost under her breath, to take care. The world condensed into a corridor in which a prosecutor would later decide whether the charges would stick. Amara, in cuffs, becomes a neat rhetorical image for the other side to deploy. The antagonist can claim victimhood. The whistleblower can be cast as the aggressor. I knew the risk when I stood at the pulpit, and yet nothing in moral calculus justified retreat when a woman's life, her dignity, was at stake. I spent the night in a holding cell, the metal bed beneath me holding the weight of many small indignities. Reynolds, ever practical, began running calls. David filed emergency motions to get me released and to force immediate preservation of evidence at Oak Haven. We were at the point where narrative social mediated. Community had to be subordinated to chain of custody and timetables. Exhibit I. Arrest report alleged paraphrase. Charges listed as interference with disposition, disorderly conduct, notations of witness statements, time of booking, the hold and the medical files. While I lay on that metal bench, the adversaries supposedly moved to stabilize their control. Oak Haven insisted to police and to the hospital that Mama required evaluation and that the documents in their records supported the transfer. The hospital performed an initial intake and placed a temporary psychiatric hold. The hold mechanism is supposed to be protective. In this case, it served as a pause button that removed Mama from my ability to advocate. David continued to press. He subpoenaed Oak Haven for original medical files. He asked for notarization logs. He requested chain of custody documentation for the cremation authorization and the DNR, that kind of paperwork. When it is honest, produces signatures with timestamps and notary affidavits that are verifiable. When it is dishonest, there are whole gaps of absence that can become proof. The first major forensic win in the days after my arrest was the discovery of those holes. At my direction, Reynolds obtained the notarization register from the municipal recording office and cross-checked the names listed. The notary listed on the DNR had no record of officiating on the date indicated. The municipal registry sent a scanned log with dates and signatures. When compared, the DNR's notary did not match the registered signature on file. That discrepancy, in isolation, is not dispositive. In combination with the bank, transfers and the IP traces, it becomes a pattern. Exhibit J, notary registry alleged, municipal log, showing no attestation on the DNR's date. Registered notary signature compared to DNR image. The counterattack. I was out on bail within 3 days. The conditions were mundane, no contact with Dominique. An order to remain within the city, unless obtained permission. And a gag line that made me feel ridiculous. Do not make statements to media. It was a reminder that justice systems are often more concerned with processual neutrality than with immediate moral clarity. We pivoted to the things authorities respect: documents, metadata, and expert testimony. I spent the next weeks building an evidentiary narrative that would be difficult to dismiss as circumstantial alone. We added 3 kinds of instruments to our arsenal: a technical trace of online activity, forensic accounting showing wire flows, and clinical evidence that Mama was competent and not the subject of legitimate, involuntary hospitalization. 1. The technical trace. Reynolds and a digital forensics specialist preserved server logs from the Instagram post and the GoFundMe. The JSON header showed an originating IP block tied to a commercial address, where Hunter maintained office space. Through subpoenas, David secured records from the registrar, showing that the LLC used to receive wire transfers had been set up 2 weeks before the alleged death, and listed a mail drop address that, on closer inspection, corresponded to a cop store that also handled Hunter's business mail. These were not smoking pistols alone, but they were threads. Exhibit K, IP metadata alleged, preserved JSON header from Instagram story, geolocation of IP to commercial block. Timestamp, matching GoFundMe post. To the bank flows. Bank records once you can access them through subpoenas tell a story of where money concentrates. Payments from the GoFundMe landed in an account that cleared to a high line. Retail card with a billing name matching Dominique's as she's from Mama, checking to an LLC associated with Hunter appeared in a pattern, small amounts first, then larger sweeps, synchronized to a credit card withdrawal. The pattern suggested a consolidation of funds that then moved through intermediate accounts and ultimately into accounts that Hunter controlled. Exhibit L, bank flow diagram alleged, visual showing deposits from GoFundMe into Dominique-linked card. AC, transfers from Mama S accounts to Sterling Holdings LLC. Subsequent wires to out-of-state accounts. 3. The clinical evidence. We contacted Dr. Thorne, an independent neurologist with a specialty in late life cognition. He examined Mama, reviewed hospital intake notes and the Oak Haven records, and provided an affidavit. His conclusion was cautious and professional, according to assessment and standardized testing he administered. Mama did not meet the criteria for an involuntary hold for psychiatric danger or for lack of capacity to make basic decisions. He flagged inconsistencies in Oak Haven's progress notes and in the chronology of alleged cognitive decline. XHBITMDR, THORNE affidavit paraphrase testing. Notation of discrepancies between Oak Haven charting and observed functioning. These 3 strands converged in a practical way when the federal agencies took notice. Money moving across state lines into a pattern of shell companies and retail accounts, plus potential medical fraud and elder abuse, elevates a local custody fight into a matter of federal interest. An agent from the federal task force reached out through a contact at the precinct. He said, softly, that the pattern looked like more than family infighting. The corrupt doctor, Dr. Marcus Evans, was a name in the Oak Haven paperwork listed as the attending physician, who signed off on transfers and the DNR. He had a private practice and a reputation for being near the top of the home visit list for local nursing facilities. What we learned was that Dr. Evans had, according to a later indictment, received payments from the same accounts that were receiving funds from Mama's accounts. Those payments, if proven, looked like compensations for paperwork and for attesting to conditions that had not been confirmed. We did not make moral assertions in press statements. We gathered records. The billing statements, when compared to doctor visit notes, showed visits listed as home visits on dates when, according to the activity logs from the building, the nursing station had no staff on duty in that wing. Dr. Evans, when contacted through a formal subpoena, produced charts that were vague on examination findings but specific on recommendations. Recommendations that conveniently matched the path to guardianship. Exhibit N, medical billing audit alleged, comparative table showing billing dates versus nursing home staff logs. Payment recipients, listed with routing numbers matching other defendant accounts. The sting, Hunter. Hunter's arrest did not occur in a courthouse or under church lights. It came at a motel off an interstate exit, the kind of place where men think they can liquidate consequences for small fees. Federal agents surrounded the room, took him into custody on charges that included money laundering and conspiracy. The affidavit alleged that he had set up multiple LLCs and merchant accounts used to receive funds from charity platforms and to move assets out of the reach of beneficiaries. The agent's affidavit was meticulous. Timestamps, routing numbers, signatures, and IP traces. That arrest, public as it became, did not instantly make everything right. It did, however, validate a central thesis we had been working under. This was not a family quarrel only. It was a coordinated attempt to monetize a vulnerable elder's estate. Exhibit O, Federal Affidavit Alleged Paraphrase, listed counts against Hunter, bank, and IP traces. Summary of Shell Company Network. The foreclosure notice. While criminal processes crawled forward, a financial countdown ticked. The reverse mortgage servicer had a practice common in the industry that allowed it to accelerate a loan when occupancy stipulations were breached. Once an occupant is not living in the property, the servicer can declare default, call the note due, and begin foreclosure. Given the house's state of partial packing, and given statements from Oak Haven indicating transfer, the servicer issued an acceleration notice citing breach of the occupancy clause. There are quiet ironies in the law. The very instrument that can be used to protect an elder's equity in theory. To let them stay in their home can also be weaponized by bad actors who remove the occupant and then create default conditions that justify a forced sale. With foreclosure proceedings set to begin, the brownstone had a countdown, sale date on the public calendar, typically 6 weeks from acceleration notice, shorter if the note had been sold to a debt buyer. This is where the path becomes financial as much as legal. The note, I discovered with the help of a title search, had been reassigned to a buyer in the chain, Phoenix Asset Management. Phoenix had purchased mortgage servicing rights from a national servicer, a common practice. Phoenix now stood in the place of the bank and could enforce foreclosure. Phoenix also had a known relationship, through investment channels, with a Sterling-linked trust. That relationship offered a leverage point. Exhibit P, Note Assignment Public Record. Assignment chain showing Phoenix Asset Management as assignee, recorded date. Foreclosure sale timetable. Negotiation and strategy. The courtroom is one theater. The negotiation table is another. If the legal route was the needle we needed to thread, the financial route was the rope that could pull the needle through. I reached out, quietly, through contacts who had once worked in institutional asset management, and asked to speak to a senior representative at Phoenix. The goal was not to plead, but to present reputational risk. A foreclosure on a house, recently the subject of alleged elder abuse, and a federal investigation would invite scrutiny the firm preferred to avoid. William Sterling Sr. did not take my call the first time. I expected as much. He had built investments and reputations over decades. He had a public persona that required smoothing. A second call handled through a contact in his philanthropic channel resulted in a meeting at a private club. Mr. Sterling and I did not speak like enemies. We spoke like people who knew the cost of reputation and the math of risk. I laid out a series of outcomes. Phoenix could run the foreclosure to conclusion. The estate would likely be depleted of costs and fees. A sterling-linked entity could quietly acquire the note and massage the optics. Or we could negotiate an immediate assignment. Phoenix sells the note to a purchaser who would commit to a workable resolution, one that protected Mama's home while ensuring financial compliance. Mr. Sterling did not want scandal. He was, I think, embarrassed that his progeny had allegedly been involved. He was willing to consider an option that would limit publicity and provide cover. We structured an agreement that, in plain terms, transferred the note to a special-purpose entity we controlled for the period of resolving the estate. The entity would pay Phoenix at a discount for the note an ordinary financial transaction, and, in return, we obtained control of the enforcement process. Which meant we could forestall foreclosure, coordinate eviction proceedings legitimately, and structure repayment to make Mama whole. Mr. Sterling's counsel insisted on confidentiality. We insisted on binding documentation that would preclude further transfers without court approval. That negotiation was not about leverage alone. It was about converting a ruinous public force into a tool for restoration. Exhibit Q, Note Purchase Agreement Alleged Paraphrase, Assignment Terms, Purchase Price. Confidentiality Clause, Covenant to cooperate with legal investigations. When the foreclosure sale date arrived, the atmosphere in the county courthouse was electric in a way that only such auctions can be. Neighbors in suits, official clerks, a line of investors watching the gavel. The lot description for the brownstone carried a notation, subject to pending litigation. That caveat reduced interest from passive investors. Because we controlled the note through the special purpose vehicle. Our agent Reynolds's cousin, who did municipal auctions for a living, appeared as the only bidder. The gavel fell. We purchased the note. The acquisition was not piracy, it was a reclamation. Legally, buying the note placed us in the position to rescind or to restructure. We immediately filed a motion in probate court to establish an accounting and to ask the judge to ratify a trust instrument for Mama. The motion asked the court to recognize the note purchase as a protective step and to permit the trustee to manage the property in Mama's best interest. Within 2 weeks, the judge issued an order that paused any eviction pending a full accounting and required Mr. Sterling's family and all named defendants to appear. Dominique, seeing the tide shift and perhaps realizing that her financial route was blocked, began to lose the performative advantage she had earlier. Exhibit A, Auction Record, Public Record, Purchase Entry, Purchaser ID, Special Purpose Entity, Gavel Timestamp. The FBI takedown. Hunter's arrest at the motel was the first visible sign of a larger federal interest. Over the next months, agents executed warrants at offices, retrieved servers, seized devices, and interviewed bankers. The indictment filed by the U.S. Attorney's Office charged Hunter with a string of counts: money laundering, wire fraud, and conspiracy to commit money laundering. The charging document referenced wire transfers, merchant account receipts, and the alleged role of shell companies in diverting funds. Charged with him was, later, Dr. Marcus Evans, who faced federal counts connected to falsifying medical attestations and billing fraud. The federal case painted a picture of a network, nursing home paperwork, a lot's attestation, shell companies receive money, and family members who benefited. The federal case also buttressed our civil posture by demonstrating systemic misconduct. It is important to note how slow due process is. Indictments followed months of motion practice. Publicity rose in waves. First the church reveal, then arrests, then auction records, then indictments. The narrative arc we had tried to control in church began to find its legal expression. Exhibit S, Indictment Public Record Paraphrase, Counts against Hunter, Counts against Dr. Evans, Summarized Evidence List. The criminal trial was not cinematic the way some imagine trials are, no dramatic last-minute revelations or theatrical confessions. It was a methodical unspooling of documents and testimony. My role was smaller than I expected, a witness. An expert in the sense that I could translate accounting flows for a jury. And someone who had to remain composed in the face of cross-examination. Dr. Thorne testified to Mama's competency. He explained, in language the jury could grasp, what a cognitive screening measured, and what it meant that Mama could attend choir, manage a thermos, and sign her own name in the weeks post-incident. The doctor's testimony was not about moral judgment. It was about clinical thresholds. I testified to the chain of financial events, where the GoFundMe payouts moved. How the merchant accounts cleared, what the shell company's payment trails looked like in a ledger. My testimony used chart-simple diagrams that mapped funds from donors to the cards in question, and then across a series of accounts before dispersal. The jurors looked at those diagrams like people reading maps to islands. Cross-examination attempted to cast every inference as supposition. Defense counsel insisted that funds were donations, that legal authority rested with Dominique's paperwork, or that any inconsistencies were clerical. That is the defense's job, to create reasonable doubt. But evidence that links a series of acts, multiple signatures with inconsistent notarization, transfers time to alleged dates of death. IP traces showing posts from a commercial block linked to the defendant's business coalesced in a way that a jury can parse. When you put enough small anomalies together, a clear pattern emerges. The verdict was not the last word in truth. It was simply the legal community's judgment on whether the prosecution had proven, beyond a reasonable doubt, that the defendants had conspired. The jury found Hunter and Dr. Evans guilty on major counts. Dominique was indicted in a related case, and later pled guilty to charges including forgery and fraud as part of a plea agreement that brought her under supervised restitution and a term of incarceration. The sentences, pronounced by a judge who noted the harm done to a vulnerable elder and the community that loved her, were sober. They were not triumphant. Exdicted. Verdict summary public record paraphrase jury findings sentencing ranges. Restitution orders. The restitution and the trust. Justice, in the form of a prosecutor's vindication, is necessary but not sufficient. Our priorities shifted to restoration. Purchasing the note allowed us to keep the brownstone out of speculative hands. David and I worked with an estate planner to create an irrevocable trust for Mama. The trust's legal structure ensured that Mama could live in her home for life, that her assets would be protected from predatory claims, and that third-party management would oversee any distributions to legitimate heirs under court supervision. In practical terms, we settled outstanding liens, cleaned the title, and recorded the trust. We put safeguards in place. Co-trustees were appointed, one a family friend unconnected to the Sterling network. One an independent fiduciaries so no single party could again manipulate access. Rochelle Patterson, the woman who had sung under Mama for decades and who had a background in community organizing, became one of the trustees. She knew the neighborhood and its people. This nomination mattered more than it might sound on paper. Stewardship requires relational knowledge as much as legal know-how. Exhibit U. Trust instrument alleged paraphrase. Irrevocable trust terms. Trustee appointments. Occupancy clauses for Mama. Mama comes home. We had to persuade a court to end the psychiatric hold and to permit Mama to return to her brownstone. That, in practical terms, required Dr. Thorne's affidavit, the hospital's discharge planning, and an agreement to monitor her care supportively. The judge signed off. Mama returned home on a crisp morning in November, carrying in her arms a small box, with the remnants of the things we had recovered, a handful of buttons, a spool of thread she insisted on keeping, and a yellowed program from a church anniversary. The house smelled like rosemary and dust and a life rearranged. Mama asked that the ledger Estelle's register be returned to the drawer beside the prayer book. It sat there like a small cathedral. Dominique had taken some things and the insurance would not cover others. The ledger remained because some things, however intangible, cannot be spirited away. We re-established a care plan. We set up a home health aide to assist with medications and with small errands. We did not live as if catastrophe could not return. We lived as women who had fortified a home against a particular kind of predation. Christmas at the brownstone. The season that followed was quiet and full. Mama insisted on hosting a small Christmas gathering for the choir. She sat in her armchair and watched the young sopranos rehearse. She laughed when someone missed a beat. She baked one pie no one asked for and insisted on giving it away. I listened at the doorway, watching a woman who had been almost stripped of dignity take back the small rhythms of ordinary life. At the table that night, William Sterling Sr. attended as a guest, rather than as an adversary. He apologized, briefly and personally, for the public disorder his family had caused. Apologies, in some cases, are not enough. Restitution matters. But he had taken steps through the note sale. Through cooperation with investigators, and his presence signaled that reputational calculus can, sometimes, be redirected toward repair. In small, human terms, the choir sang. Mama's voice, though softer, still held the same phrasing she'd used for decades. She led a verse, then laughed at a missed note, and then leaned over to me and said, "You kept my ledger safer than I did." I hugged her. We did not speak of Dominique much that night. The absence of some people can be its own kind of present. Reflections on family and power. This story is not simply about a criminal conspiracy. It is a study in how social structures, trust, reputation, religious authority can be weaponized. Someone who controls the narrative can quickly shape a communal response. Social proof is a currency. Someone who can access a set of instruments, medical forms, merchant accounts, courrier service can transform a personal act into a financial extraction. And someone who knows how to move money can, in a matter of days, convert sympathy into liquidity. But this is also a story of what happens when data meets devotion. A ledger, a timestamp, a notarization log, these are not cold things when human dignity is at stake. They become means of restoration. The forensic work was tedious, and often tedious in ways that were morally infuriating. Crosswalks of receipts, signature analyses, phone pings. But each file we preserved and each subpoena we served was a small act of repair. A caution. The public face of the case, the dramatic moments of the church, and the arrests dominate headlines. The quieter parts, the long motions, the discovery process. The trust paperwork are the foundation of any durable recovery. Systems respond to evidence. Advocates respond to systems. The two together can rebuild. Exhibit V. Restitution plan, alleged paraphrase. Court-ordered restitution schedule. Schedule for sale of recovered items to pay damages. Terms for ongoing trust distributions. The moral of the ledger. Mama kept her life with lists and a pen. Her ledger was small, human, and imperfect. People took what they could, not always with malice, sometimes with expedience. The legal system, imperfect as it is, can restore, account, and sanction. The community, if given the facts, can rally to protect what is valuable. I am not here to proclaim that the law is the same as moral justice. It is not, but it can be a bulwark. The greatest tools we used were not secret formulas. They were persistence, the patience to collect records, and the courage to make difficult choices in public. I also learned, painfully, about the limits of proximity. Blood does not excuse the theft of trust. Family can be both shelter and weapon. So you choose whom you let into the inner rooms, and you set legal and financial boundaries to protect what matters. Epilogue: what we did afterwards. We created an irrevocable trust for Mama that protected the brownstone for her lifetime and specified responsible beneficiaries. We reconstituted the household with supportive services and a trustee council that included community members. Court-ordered restitution and criminal sentences were part of the resolution. Federal charges against Hunter and Dr. Evans resulted in convictions and sentencing that included restitution orders. Dominique pled guilty to charges that included forgery and was sentenced by a judge who emphasized rehabilitation and restitution rather than spectacle. None of those facts erased the wounds. Reconciliation with Dominique was, for Mama, not an option she sought. Boundaries can be a gift. They preserved space for healing. Afinal hoje. There is a temptation in stories like this to treat every human relationship as transactional, that is a lie. Families are not ledgers even when ledgers are saved. But the mechanics of fraud are real, and those mechanics can be addressed. If you are caring for an elder, take small, practical protections. Know where their documents are. Preserve original copies, and have trusted allies who can speak for them. That is not legal instruction. That is prudence. If my story leaves you with a single image, let it be simple: a woman in a blue dress walking into a church and knocking an urn off an altar. The image is dramatic, yes, but its power lay not in spectacle but in the fact that a life an ordinary, liturgical life was almost stolen, and then, by stubbornness and legality and the small mercies of community, recovered. If this case resonates with you, if you have been the person who found themselves the odd voice in the room, tell me in the comments. I read them. If you like investigative stories that take the time to follow papers, follow Peopli and Honors with Fact, subscribe more. There are more stories to tell, and there is power in collective attention. Thank you for staying with this one. If you want to watch another long-form investigation into family fraud and legal drama, check the playlist linked at the end.